No, thank you. Good afternoon, Stephen, and to the viewers. I think it's going to be a tough decision. It's going to be a mountain to climb. And now looking at the requirements of the Correctional Services Act of 1998, and you have correctly pointed it out, that the parole board that sits and makes the decision, that is the final decision in relation to paroles, have indicated that the former president did not qualify to actually receive that parole. And reading that with the judgment that was given, it was a tight judgment. It shows that there was non-compliance with the law, and it becomes problematic, Stephen, if there's non-compliance with the rigorous tests and applications that are required by the law in relation to giving a parole.
So in the end, I suppose it comes to Arthur Fraser. I mean, he said very proudly, he gave an interview to the SABC, he said it was his decision. I mean, it comes down to whether he has the power to make that decision. From what you're saying, he probably doesn't.
Yeah, absolutely. Yeah, he doesn't, because the law does not actually give him that authority, because he has to do that in consultation with the board, and that is what the appeal will turn on. And so basically, the requirements of the law had to be followed to the T, and that was not done, and it was clear. And you have indicated that that interview is another exposure, because it was done in public, that it was done as a sort of a favor which was being done, and that is not what is supposed to be done, because the law has to be applied equally, in terms of the Constitution, fair, without favor, without fear, and without prejudice.
So in this application, it was probably a mistake to go public then for Arthur Fraser. He would have been in a better position legally if he had just shut up.
Absolutely, you're quite correct, Stephen. Some things that you have to deal with them, you will have it within your wisdom when a decision like that has to be taken, to actually not say and get ahead of yourself. So that exposes the whole thing, and it becomes problematic, because South Africans want to see the law to be applied fairly and equally to actually you and me, Stephen, without fear, without favor and prejudice, following the process of the Constitution. And we've seen that there is a lot of an outcry of other people that have applied for parole with merit, and their paroles were not granted, and it creates a problem.
There's another key question in all of this, which is actually quite complicated. So there's parole, and there's medical parole, and there's time served. And let me try and think my way through this. You're the one with the LLB, not me. So the question will come, I think, where Zuma was sentenced to serve a certain amount of time in jail. After serving a certain amount of time, he would qualify to apply for parole. But if he was released early, which he was in this case, does that mean that the time he's now been at home, so he hasn't been a free man, he's been at home, does that qualify as part of the time that he has served or not? I hope I've explained that properly.
No, you have explained it correctly, Steve. You have a very good experience as well in relation to this matter. So look, the judgment has made it clear that the moment he was released from the gates of prison, that was an unlawful act that was actually done. So for him, being out of prison is unlawful. So in terms of counting the time, the time that he is not served was not sufficient enough to have him even released on those bases that you have actually indicating, of calculating the days for him to qualify to automatically be released by serving, a portion of his sentence. So basically, that argument will actually not help him at all, because the release becomes unlawful.
So does that mean then that in the longer run, it may actually sort of be against him? He's going to serve a longer time than he would have if he had just waited to serve a certain amount of time before applying for parole, because that time won't be taken into consideration.
Absolutely, Steve. You're quite correct to say if he had served the time and qualified in terms of his sentence to be released, it was going to actually work in his favor now. But now, the time that he spends outside, it's calculated as an unlawful time. If the judgment is confirmed at the Supreme Court of Appeal, we go back to where we are actually coming from in terms of serving of the sentence.
So then this leads to another question, Romeo. Normally in these cases, and there's plenty of history here, I think I can say this quite safely, the former President Jacob Zuma appeals decisions many times, always goes to the Constitutional Court in the end. But the longer this case takes, the longer he could end up serving. So would it actually not be in his interests to appeal?
Yeah, it's on both sides in terms of what we are indicating, Steve, it jeopardizes his chances, and the more the appeal delays longer, the more it affects this process of actually serving the sentence and being a candidate to qualify to be released on parole. So the more the delay, the more the uncertainty in terms of him serving the time becomes on him. So he's not going to have that argument of saying that, but I have served a bit of time when I was inside, because he was released unlawfully, so as the judgment in the Pretoria High Court has actually indicated.
Romeo Nthambeleni, I really do appreciate the time. Thank you very much indeed. It does seem to me we're going to have appeal after appeal in that particular case. A very important case. You know what happened, of course, last year when the former president, was actually sentenced. Well,